before. But my name's Eric Staszczak. I'm Executive Vice President here at Westward 360, responsible for business development, and previously having been the department head for our association operations since about 2018 as well, and with the organization for about 12 and a half years. We've been doing these educational sessions with board members, potential prospective board members, folks that are interested in learning more about our management services, who might be managed by a different company or might be self-managed, all in the hopes of empowering you with just better and more detailed information to just make your lives as a board member simpler, easier, making sure that you have the proper guidance in how you're governing and operating your community. So we've covered a number of different topics since we launched this program back in July of 2020. We'd like to, this is the second session that we've had the pleasure of having Dawn Moody here with us. We also have Carrie Surratt, our general manager in Naperville and Tinley Park, and president of CAI-Illinois as well with us. But I'd love to just give a couple of quick introductions to them and give them the floor for a moment. And then we can go ahead and get into the presentation. Carrie, maybe if you wanted to introduce yourself, and then Dawn, we can kind of have you introduce and transition us into this presentation.
Okay. I think you did a great job for introducing me, Eric. I'm Carrie Surratt. I am in the Naperville and Tinley Park office for Westward 360. I've been in the industry just over 26 years. And as Eric said, I'm the current president of CAI-Illinois, our local chapter that is all things associations.
Yeah, I guess it's my turn. I also agree that Eric did a fabulous job introducing me. My name is Dawn Moody. I am one of the principal attorneys at Keough Moody, which is a law firm in Naperville, which concentrates its practice on the representation of condominium, townhome, and homeowners associations. Since we are all telling each other how old we are tonight, I have been in the industry since 2000. I started at a version of the firm called Knuckles and Yeagle back in 2000. And have been licensed as an attorney for the past 21 years, simply working with community associations. So tonight, we're trying to do something fun and entertaining while also educational at the same time. So again, I hope I'm not dating myself with age, but David Letterman had some great top 10 lists back in the day. So we are doing a David Letterman top 10 board don'ts, what to avoid to doing in your community. And governing your community association. So a couple housekeeping issues this evening. For my purposes, I'm providing general information. I am not providing legal advice. In the event that you have a particular legal question, it is good that you reach out to your association-specific attorney to get an answer based upon your specific association's governing documents. Again, tonight I'm just providing some general information. And the law and order disclaimer, any stories that Carrie, Eric, and I might tell tonight, they're completely fictional. If they sound familiar, trust me, it's not your association. It's not an association that anybody knows. These are all essentially made up facts or, meshed facts. There is no basis in actual truth. So again, this is a work of fiction this evening when we start talking about stories. And with that, let's dive in. All right, the top 10 don'ts in govern your community association. And this is a good one to start with, especially because we are going into budget season this year. I feel like we were just in budget season for 2025, and now we're back in it for 2026. Don't forget that you are running a business. Your condominium, townhome, homeowners association, it's a business, and it should be run like a business. You should have finances. You should have, projections about what needs to be done this year, 3 years, 5 years from now. You have your corporation protected by corporate laws. You have specific contractual responsibilities that are set forth in the association's declaration. And as board members, there are things that you are supposed to be doing, you must be doing, such as acting in the best interest of your association and its members. And from time to time, that might seem like it's competing because, again, we're talking about budget season right now. So if you ask your homeowners what is in their best interest, they are going to tell you that in their best interest, it is either not raising the assessments or reducing the assessments. Whereas what is in the best interest of the business, that is the association, very well might be raising the assessments in order to make sure that you are meeting all of the association's contracted obligations. So as board members, you have to determine what is best for the business that is the association. With conjunction with your managing agent, what things need to be on the budget for 2026, which things you should be looking at. And you have to make those hard decisions of increasing assessments or perhaps doing a special assessment to make sure that the needs of the business are being met. Other things to keep in mind when you are running a business that is the association is to bring that work mentality into your board meetings and into your communications with your community association management team, with your fellow board members, and with your owners. I have a lot of boards that don't like each other. They just do not like each other at all. And there's a lot of drama, for lack of a better phrase, with those boards because they cannot figure out how to work together. And what we try to keep drawing them back to is think about if you're at work. You work with people that you don't necessarily like and that you don't necessarily agree with. How do you get by at work? How do you continue to not end up in HR, not end up getting fired because you're acting inappropriately? Bring that into your board meetings and make sure that you're communicating with the members of your team and with the owners of your association in a business-like and respectful fashion. Again, make sure that you are concerning yourself with the financial viability of the association. When you get that reserve study for your association, after you fall on the floor from the numbers that are in it, make sure that you're making a plan so that reserve study is being met in the years going forward. Eric, Carrie, do you want to jump in and add some practical things from your side?
Yeah, I mean, I couldn't agree more on those points. I think in my experience, your point about, how do you get along with folks like in a professional setting with whom, they're not always your best friends. They're not, and even sometimes when they are, while that might seem convenient or like helpful or that like, your relationship gels, you also need to make sure that you're kind of emphasizing the professionalism around that too, right? Like you don't want to give the impression that you're sort of in cahoots with your, a certain fellow board member just because you have a friendly relationship. Like there are going to be opportunities that exist where you don't see eye to eye with your peers on the board, or maybe your business-like mentality doesn't, necessarily reflect like Dawn mentioned, like owners that might want low assessments or reductions in assessments. But I think ultimately when you're treating it like a business, that's how you justify and control some of that messaging. And I think that gets helpful the more and more that you can emphasize that, even in like the communications that you send around those things. So, showing, homeowners that you don't take these decisions lightly. It's not your favorite thing to have to do, to have to hit, owners with a hefty increase. It's not like you're enjoying that process necessarily. But ultimately, it's probably things that they're going to thank you for in the long run. We recently took over a community that started with us effective, I believe, September 1st. And one of the things that came up at their introductory meeting with us in front of homeowners to kind of orient everyone and introduce ourselves was that for a long time, they had a board that because they listened to like the request of lowering assessments and things of that nature, they did it for 10 years consecutively. And what they had to do was come up with a $15,000 per unit special assessment very suddenly because they finally had a board that was treating it like a business. Now, was the board worried about the stink that kind of came around from them because it was, hey, the new administration wants to do this? The way that they were able to do that was they communicated and showed, hey, the way that this has been run for the last decade, it's been incongruent with running it like a business. They ran it, as if everyone in the community was their family and they didn't want to hit them with those things. But once they got things professionalized, they ran it like a business. They communicated well and thoroughly about those decisions. People ultimately thanked them and said, I know it was difficult. It wasn't the easiest thing to communicate, but the association was much better off for it. And they're at a much better sort of jumping off point for success going forward. So They're difficult conversations sometimes. They're not always the most pleasant, but we can always help and supplement with tools to make the messaging around those things easier and still keep a sense of community while operating your community as a business.
Eric, as I'm listening to this story, I'm reminded that it doesn't matter what decision a board makes in terms of assessments. Your owners are always going to be mad about it. Maybe not today, but they're going to be mad about it. You increase assessments, they're not going to be happy about it, but they will be happy about it, 5-10 years down the road when you've avoided a special assessment. If you don't increase assessments, they're going to be happy about it in the moment, but when you're at that special assessment meeting 10 years down the road, they are not going to be happy because they're going to want to know, why didn't you do this stuff then so that we didn't have this problem now? So your association is a business. Make sure that you're making good financial decisions for your association. You are fulfilling the contractual obligations. You're doing the things that you're supposed to do, checking the boxes. And most businesses, you're looking to make a profit. We're going to do this and we're going to make a profit. For associations, you're looking to make sure that your building is being maintained and your property values are going up, not down, because the property isn't being properly maintained. And with that, we can go to number 9.
Great points. One quick interjection just for everyone in attendance. If you do have any questions and you don't want to forget about them and want to just jot them down, feel free to throw them in the chat. We will get back to them after we conclude Dawn's presentation and anything that we go through here. We will get to it for sure. But if you're like me and you're like, I need to remember this and I need to get it out there, feel free to post it in the chat there. We will go through those questions at the end of the presentation as well.
All right. Number 9, don't sign major or long-term contracts without legal review. As an attorney, this is something that I'm very much going to get on my high horse about because it is something that is very important. None of the association attorneys out here have a time machine. So if you end up having a problem with one of your vendors, we are unable to find a time machine, go back in time and fix the problem. We are stuck with whatever the contract is. So questions that I will occasionally hear from board members is, should we have every single contract reviewed? I mean, in a perfect world, yes, you should have every single contract reviewed, but to a point, that's a waste of everybody's time and money. The contracts that you should have reviewed are contracts that are multi-year contracts. So we are signing our landscaping contract for the next 6 years, and contracts that are a high dollar value amount. So what a high dollar value amount contract is going to vary from association to association. What I would say is, if things go south and you have to walk away from spending that money, are you okay with it? So if it's $10,000 and things go south and you're out of $10,000 of association money and you're okay with that, don't necessarily have that contract reviewed. But if that is a lot of money to your association and things would be very bad if you lost that money or something went sideways with the contract, have it reviewed by your legal counsel. It is much easier to prevent a problem than it is to fix it. It is much more cost effective. Tonight, again, we're telling stories that have absolutely, they have no basis in fact. We're just making them up. So the story that I'm currently making up involves, an association that said, we don't need our attorney to review this major contract for siding replacement. So the board signed the contract and away they went. And the next thing you know, they're getting hit with a mechanics lien from a materials supplier. And we've been working for the last couple of years trying to get this mechanics lien foreclosure case dismissed. If we would have had some requirements in the contract about mechanic lien waivers being provided to the association, material waivers being provided to the association before final payment was issued, we likely could have prevented this problem. But instead we're in litigation. So I'm going to say a $600 contract review can theoretically end up being $60,000 in legal fees. If you would like to save your money, have your contracts reviewed, because it's much more cost effective to have the contracts reviewed, have the problems prevented, versus having to go into litigation after the fact. Contracts are always going to be drafted in favor of the drafter. So the contract that you have, and I'm sorry for picking on landscapers tonight, but the contract that you have for landscaping services is meant to benefit the landscaper. The contract that you have for roof replacement, it's meant to benefit the roofer. So there isn't necessarily an even playing field unless somebody is taking a look at that contract on the association's behalf and saying, yeah, we're not agreeing to that. We need something to be a little bit more reciprocal. By that, I mean, one thing that always jumps out at me in contracts is there is language that says in the event the contractor or the vendor has to sue the association for something, they're entitled to collect all of their attorney's fees. But there's nothing said about if the association has to turn around and sue the vendor for compliance with a warranty or something else. So if the association has to sue the vendor, they're not able to recover their attorney's fees, but the vendor is able to then recover their attorney's fees if the association doesn't pay. So the right should be reciprocal. If we end up in court on something, both parties should have the right to recover their attorney's fees, and the attorney's fees should go to the prevailing party. I believe that should be there because it's also a deterrent. It gets people to the table. We can all talk about suing people when we're spending our own money, but when we have the potential to not only have to pay our attorney's fees, but also the other side's attorney's fees in the event that we do not prevail, it helps bring the parties together to have a conversation to solve things versus everybody just saying, we're going to litigate this as far as we want to because we can control our exposure with attorney's fees. Other things that should happen, boards should always review their contracts to determine that the scope of work is accurate. Even if you send your contract over to the attorney doesn't know that you picked a specific shade of Sherwin-Williams paint that isn't on the contract. That's something that the board would need to review and catch. So everybody should be looking at their contracts. And once they hit a certain dollar amount where we'd be really upset if something went wrong with this, those contracts should be reviewed by the association's attorney. And again, same thing for multi-year. If you're locked in for 5 years, have it reviewed. Carrie, you're dancing.
I did because I have one, and it's funny enough that I think even the small things in the contract, that fine print, small stuff that you and the board may overlook, is something to have the attorney review as well. My fake story is I had an association that signed off on tree trimming for some sort of disease, and the total price was less than $500. Yep, Dawn, you'll remember this one. And
we make this one up together.
Yep, the fine print said it was based on 118 trees per tree. So, and they were supposed to invoice a 30% deposit, never did. And when we got the $30,000 bill, there was a total shock to the manager and the board because that fine print, sneaky little in that they had there wasn't caught by board or management, and had the attorney review that, we could have saved $30,000.
Yeah, I was telling Eric and Carrie today a story from decades ago where a board did have a contract reviewed, and it was a really strange contract. It was probably a $500,000 contract, and it provided that the board would pay 75% of the contract price up front as a deposit. And that was a red flag to me of that's a lot of money that we are handing to this contractor that we have no idea as to whether he's going to be able to be licensed and get a permit from the village in which this work is being done. And I brought all those concerns to the community association manager, and I prepared a writer to address those concerns. And they just were like, you know what, this is too complicated. We don't want to hurt the contractor's feelings, and essentially threw my writer in the garbage. So lo and behold, they give him 6 figures worth of money, and he cannot get a permit from the village. So at that point in time, the contract needs to be terminated because he can't do the work legally, and we can't get the money back. He had taken the money and essentially spent it all. So that check from the association made him solvent. We did pursue legal action, but this is one of those situations where you can't get blood from a turnip. He spent it all. He had a really, really nice Christmas from the bank statements that we reviewed. So those are the sorts of situations that happen that we don't want to see happen to another association. So it's why we very strongly encourage, don't sign these contracts that are for a lot of money or for a long term without making sure that you have your counsel review them and that they're very carefully reviewed by the board, because it is so much easier to prevent the mistake than it is to fix it after the fact. So if you're trying to save money by not being in a lawsuit. All right, number 8.
And I think I'm taking this one, right, Dawn?
You are.
Yeah. So number 8, don't hire uninsured or unlicensed vendors. Again, I think for some of you, like some of these might seem straightforward, and maybe you do operate this way already. I will tell you from our collective experience, this is one that routinely and continually tends to be fairly problematic. Despite, we have a number of systems on our end that we've always used and a number of compliance policies that are part of our everyday process and procedure to make sure that the vendors with whom you all are working at your communities are being properly vetted, that we're collecting those compliance documentation pieces, whether that's a certificate of insurance, a declarations page, evidence of license and bonding, all of those things, particularly to Dawn's point on the previous slide for those really large, big ticket projects. Obviously, those things are, bar none, you always need to have those in place. Sometimes associations, even larger or more complex ones, think or have the misunderstanding that for the small routine jobs or, the little bit of handiwork, the risk is low, let's not worry about it. We've always known, Albert next door as being a really great painter, whatever the case is. And I will say this tends to be a little bit more problematic for some smaller associations that, maybe the cost of doing business with more professionalized, properly insured, licensed and bonded vendors is sometimes a barrier of entry at times. But the what you save in terms of the due diligence and maybe a little bit of that price increase for some of these things to make sure that they're properly documented and insured is going to save you the potential headaches that can really come out of this and cause huge problems, large and small. It doesn't take a lot for whether someone gets injured on site and not knowing for sure what the status of their liability insurance, there's workers' comp insurance, going into that, to that painting example, someone could walk into your entry and maybe they have a step ladder up and they're, just doing a little bit of touch up, and someone opens up their unit door that opens up to that little vestibule and knocks them off the ladder. What you thought was just going to be a quick and easy 30-minute job now potentially has a good deal of liability involved with it. Obviously, if everyone's done their due diligence and proper insurance documentation was in place, even though the situation itself was an unpleasant one, we have the proper recourse. We have the proper channels. We have the right insurance information on hand. We have the right places to escalate the issue to. And there's not this kind of opaque, oh crap, what do we do now kind of situation. So making sure that the vendors with whom you're working, regardless of whether they're performing a $100,000 job or a $10,000 job or a $1,000 job or your $250 quick dispatch, making sure that they are properly insured is huge. We've had liability issues on this over the years with, associations that come to us and say, hey, you know what, we understand that that's best practice, but, we've always had this agreement or this arrangement with this particular vendor. Maybe you live in a nice little niche neighborhood in the city, or in your municipality, and there is that local landscaper who you're like, hey, you know what, we don't have a big footprint. He charges a really reasonable rate and we want to, help him out. I get the sentiment behind that. And I think your heart's in the right place. But again, you're running a business. This is, if you were operating your own single family home and this is a decision that's yours and yours alone and only affects you and you're owning that risk as an individual, that's a different story. That's your prerogative and that's the way that you want to operate your household. When we're we're talking about making decisions on behalf of the community. You're talking about the business, the community as a whole. You don't want to open up yourself to that liability of suddenly something happens and now you have constituents to answer to. You have fellow board members, maybe, if you're someone that, push that decision forward, or we're really strong arming the manager to kind of go forward with that. You have owners that might be all bent out of shape if something came out of that. And as a result, because that person was not properly insured, wasn't properly licensed to perform that work, the recourse to resolve that problem, to Dawn's point on the prior slide, might be a lot more expensive than the costs of just making sure that they were on top of those things. So on our end, I know that we'll always make sure that if a vendor isn't in our system, we'll collect that certificate of insurance and that declarations page, ensure if they're performing a trade for which they need that license and bonding in place, that they have that documented. Obviously, if you're taking on a much larger capital project, maybe an engineer's involved and maybe there are other parties involved that are going to be overseeing some of those compliance pieces, that's important as well. I will say one thing that we do is that in the event that you do have an association or amongst your board, you've made that decision and you are that adamantly opposed to having to, you want to work with that vendor, we do have a waiver that you can sign off on that says, okay, you're making this decision knowing the liabilities involved with, and we do not accept liabilities and things that come along with that. So if you make that decision to work with that unlicensed or uninsured handyman or janitorial resource or whatever the case is, there are ways for you to continue to do that. We do not advise that you do so. We will give you a waiver if you do insist on working with that particular vendor, just to make sure that we're protecting ourselves and making sure that you acknowledge that despite the best practice and the proper process here, that you acknowledge the risks that are associated with that. So again, if it's that important to you, we can always have that conversation. I don't think our answer will change about what our advice is in that situation, but we do have, some ulterior methodology around that if that is a sensitivity, but we will absolutely require it. We don't want people setting foot on premises performing work on behalf of the association without those assurances and protections in place. We do have, to Dawn's point about, things that come to mind from a collation of experiences. One of the things that in contract, this actually kind of combines 9 and 8 a little bit. We had a community that took on a roof replacement project. And one of the things that they did not have read in the fine print, because they did not go through the attorney review process, is that the contractor had pretty much unlimited license to sub out various aspects of the scope of work. Happened with that is that a subcontractor ended up working on some of the torch work on that roof to bind the layers of membrane to each other. And lo and behold, a torch was left out overnight, and the gas supply to that torch was also not turned off. So something did spark a fire on that. It caused a pretty catastrophic event. A number of folks had to be relocated out of that building, and it created a still, as of now, unresolved claim issue. And this is dating back at least 3 years, if I'm remembering correctly in my my fictional sort of storybook in my head around this. But those are some of those things that between contract review, between making sure that you have those things in place, those are some of those risks that can become really problematic. And that became, it wasn't only the contractor that folks were upset with. Folks got upset with the board because they felt that there were steps in the due diligence process prior to that contractor stepping foot on premises that were missed. So just to kind of give you a look into what some of those ramifications could possibly be.
One of the things that comes to mind that I just kind of want to piggyback on that story and the things that you said is, it is really important that the association review its insurance and the policies that it has in place in terms of commercial liability, your umbrella policy, your property coverage, and making sure that you are properly insured. Workman's compensation is something that pops up rather frequently for me, where boards will say, we don't have any employees, so why should we have workers' compensation insurance? And it is meant to be that safety net in the event you bring on that uninsured person, or the person who's got the liability insurance, but he doesn't have workers' compensation because the law doesn't require it because he's a one-man shop. He gets injured on your property doing work at your direction. We now have that additional coverage because he might be making the argument, well, The association was my employer because they were the ones telling me what to do. So insurance, preventative maintenance, I mean, it's not just for your roofs. It's not just for your common elements. It's also for your business practices. So making sure that you're reviewing your insurance policies with your agent every single year to make sure that you have the necessary policies to protect your association. Because when your building catches fire from the torches, you want to make sure you got the coverage to rebuild your building. And then after the fact, they're going after everybody else and hope they have insurance. All right, number 7. Don't confront owners about violations, unpaid assessments. So the thing to remember from this slide is no good deed goes unpunished. I know that we want to be good neighbors and we want to communicate with our residents and see what's going on with their violation. You know, why haven't they mowed their lawn in the last month and a half? Why has the window not been fixed after it's been broken? What is happening? And I appreciate the neighborly approach, but it ends up causing potential problems for boards. The first thing is, in this day and age, even when management sends out one nice warning letter saying, hey, you might have missed that we have a rule that says you can't do this, the response back to management is often, you are harassing me, please stop harassing me. If you are having that conversation with an owner in person, I assure you they are feeling threatened, they are feeling harassed, and oftentimes they are filing a police report against the board member that came to their door just trying to be nice. That is the best sort of circumstance. There's also been situations recently where board members, again, trying to be nice, trying to be kind, going to their neighbors and saying, hey, I want to bring up this issue with you, only to find themselves being assaulted by the owner they were trying to help. It is a safety concern. You do not necessarily know what you're going to get from your neighbors. So I'm a big fan of let's do things through the normal formal process. It helps us ensure that we have a paper trail. It doesn't let anybody really make a good harassment argument because one notification from the management company does not meet the definition of harassment in any world, and keeps everybody safe. Because you never know what sort of neighbor you have and what sort of bad things can happen. So no good deed goes unpunished. We have formal processes for a reason, meant to keep everybody safe and to keep a paper trail. So Eric, Carrie, if not, we can move to number 6.
Yeah, I mean, no, the only, and I'll keep this very brief just so we can keep things moving. The only thing I'll add is that the other thing is like enforcement consistency. Like, I think that one of the things that on the, what seems like a positive at first, you know, maybe you do take that neighborly approach and, you know, hey, I like a sense of community. I don't like people feeling like they're under, you know, a police state or under the thumb of management, whatever the case might be. The problem can be, though, is that maybe you do have a positive like interaction with that owner and they say, hey, you know what? Thanks for that reminder. Thanks for that heads up. I appreciate the additional quick warning. And now they've taken care of it. Now, what if like someone sees that interaction and then someone else is being, you know, issued violation letters for the same exact thing, but they didn't get that additional sort of like that neighborly little step or that little polite nudge from the board to kind of keep things, you know, from the paper trail. Now you've got an inequity in how the issue is being enforced too. So that person could then claim, hey, you know what? The board, you know, softly reminded this person of this delinquency and gave them a reminder before it got escalated to collections. Why didn't I get that same benefit? And now it debases some of your authority in terms of how you're enforcing those things. So consistency for things like the collections and AR process and violation enforcement is also key, so that even if it's, you know, real or contrived, that no one can make that argument that you're ununiformly enforcing or you're playing favorites or you're giving some people a benefit of the doubt that someone else isn't receiving.
Yeah. This came up at a seminar I did earlier this year. And the manager said, well, I reached out and called the former board president, who's, you know, former board president is no longer on the board, because we were getting complaints about fireworks on 4th of July. First, I don't know how they figured out this was the one guy doing fireworks, because that probably wasn't the case. The entire neighborhood was up in fire that night. But it is that selective enforcement thing. So the former board president got the phone call to say, hey, can you stop letting off the fireworks? But, the other 200 people lighting up fireworks in the subdivision, they're not getting any sort of soft warning. You're going to send them a violation letter if you have a complaint. Like, I personally feel like 4th of July, especially where I live, is there's no rules that night with fireworks. They don't exist. We're not issuing violation notices. We're not calling the police. We're just suffering through 4th of July and the fireworks. And then we're going to go back to normal, business as normal, July 5th. So we'll move on to number 6. So kind of hand in hand with this, as board members, you have the duty of confidentiality. So those violations and what's happening with this owner and what's happening with that owner, that is stuff that is not meant to be shared with other owners within the association. While they believe that they have a need to know, they do not have a legal right to know what's happening with violations, what's happening with delinquencies, who are we going out to bid with for roofing? What do those bids look like? There are things under the Illinois Condominium Property Act and the Common Interest Community Association Act that are supposed to be discussed by the board outside of a noticed meeting or separate, from the open portion, so that the board can speak freely. Things discussed there are not supposed to be discussed with non-board members. Certainly management legal counsel is going to be excluded from that, but hey, did you hear about Carrie? Here's, she's got quite the story going on. This happened and that happened. And, she's got 6 violation letters from Eric. Those things are not supposed to be shared with owners. Other things to keep in mind, and this is just a best practices thing, board members should have their own, in my opinion, association-specific email address, where all of the emails and communications involving XYZ Association simply goes to this email address. I recommend that because number one, it ensures that the only person that's looking at that is you. You do not have to look at it day in and day out, because I know the number of emails that board members receive, and sometimes you don't need that sort of negativity in your day. Your emails, if they are shared, so if you have a, spouse email, Dawn and Mike Moody at hotmail.com, again, showing my age. If both of us have access to that, that breaches the duty of confidentiality, because my husband can go in and look at my association specific emails. Same thing with your work. If you're conducting business from your work email, theoretically, other people can look at that email. Here's the other thing. If you find yourself in litigation, you are in a lawsuit and discovery is issued, do you want to have a subpoena going to your IT director at work saying, send me all these emails with this? You don't. So please have specific email addresses just for association business. I don't think Hotmail, you can still get new accounts, but I do know that you can get them on Gmail. So you can set up your very own Gmail address for, Dawn, best association ever at gmail.com, where that is your email address just for board business. So again, circle of trust, you're getting information, keep that information confidential. If there's a question about whether information should be shared with others, certainly ask your manager, ask your attorney. We are happy to tell you what things can be shared and which things should not be shared. All right, next slide. Eric, this is you and the slide speaks for itself.
Yeah. So number 5, don't be an ostrich and ignore capital maintenance and repairs or reserve studies. So whether it's been, due to fairly obvious, maintenance, degradation or deferred maintenance items that you've been aware of for some time, whether it's items that have been called out in your reserve study, if you've done one recently, or had it recently updated and just have not looked at it recently, don't let those creep up on you and just hope that they go away. They never do go away. That is there's very few certainties in life that we can share. I will say that capital deferred maintenance never goes away. it gets worse, it gets more expensive, the liabilities involved with not addressing it, or at least starting the planning process. Those things just, they will, there's only a negative outcome in continuing to defer that. Obviously, we understand that there are budget constraints, there's planning that goes into it, but let's at least start the planning. If there's concerns around, the financing around those things, we can start having good, productive conversations around that. Whether you find yourselves in a, not ideal situation in terms of your reserves balances. That's what, opportunities to talk to your banking institutions or lending institutions might look like. That's where diving into your budget and your capital reserve needs this and next year and years forward start factoring into, what assessment increases are you looking at? Do we have to consider the all evil special assessment option? Those things, if they are realities, that's what they are. Again, it's a business. It's not, something where you're just trying to save a buck and just hoping that, we can just limp along. You're representing not only your own interests, but the association's interests as a whole. I know that sometimes, owners obviously don't like the idea of having to come up with more money in those situations, or maybe you just got wrapped up with a particular project. This one also comes up a lot where, hey, we just had a heavy, summer project season in 2025. Do we really have to consider big disruptive projects in 2026? And the answer is probably yes. I mean, it's hard to get away from those things. Even if it's work that that can't be accomplished next year, there are things that come up. There are things that might be referenced in your 22.1 disclosures, things in your paid assessments letters, things that ultimately will come back to bite you if they're not looked at, on a routine basis. And if you're not keeping things like your reserve study, any sort of property report, any results of inspection reports, even things that are, that's one of the reasons that for our premier communities or on-site communities, the whole reason that we have, managers performing consistent walkthroughs, doing annual or biannual inspections, hopefully calls out some of those things. So at least if, we see a nugget of a potential issue, it's at least putting it on your radar that it needs to be looked at. But just ignoring it or hoping that it goes away, or just, I only joined the board because I wanted to push through a couple of my pet initiatives. I want to get out before we have to deal with this. It's not a responsible way to go about the maintenance of the community. The conversations need to happen. The planning needs to happen, and understanding what your capital needs are first and foremost are ultimately the highest priority. You don't want to be going into, budget season is a timely kind of event to and confluence of this presentation to kind of consider these things. You don't want these things getting worse and then suddenly it's an unbudgeted capital expense, and now you're really in a tight spot where there has been zero planning into it. You don't have the luxury of being able to, hey, you know what, we're going to schedule some time to meet with the lenders to see what our loan options and financing options might be. Now you're being backed into a corner, and you have fewer arrows in your quiver in terms of what options do I have. So that's where, that emergency special assessment of everyone having to cough up fairly immediately, $3,000, $5,000, $10,000, $30,000 in some cases, with the right planning in place, with, hey, we don't have to worry about this until 2027. That's only 2 years away. Start having the conversations around it now. Don't ignore it. Even if it's a hard conversation to eventually have with the community, it's best that you've done the due diligence to know what those liabilities are, rather than it being a surprise to you and the rest of the community when you kind of look like you're on your toes or on your heels, not having seen this coming.
So I want to jump in on this. And I can remember early in my career sitting with a board and looking at their reserve study, and the board was starting to plan, and their position was essentially, there's really no reason for us to plan for the future based upon this reserve study, because our plan is to be dead when we have to do this capital maintenance. So it was an older community, and they're like, we don't care. We're not going to be here. We're going to be dead, and it's going to be somebody else's problem. That was a good 20 years ago. So we're now kind of at that point with that association. Well, they absolutely need to care. It's a bigger deal than it was because of Fannie and Freddie. It is a bigger deal than what it was because of the Surfside collapse. So Fannie and Freddie, who back the majority of loans currently in the United States being issued. So it's not the whole, FHA stuff. It's every single conventional loan that is being written in the United States. The majority of those are backed by Fannie and Freddie. They have issued dictates to their lenders saying, you need to look into all of this information before you write a loan. And deferred capital maintenance is one of the top things that they're taking a look at and saying, if you have significant deferred maintenance, so we're just ignoring those balconies because we hope, somehow they're gonna get better in the next 5 years. You have a report, a code violation, something saying you have a safety concern. Lending within your community is going to come to a screeching halt, because if Fannie says, yeah, that doesn't meet our standards, nobody is lending in your community. The only people they're going to be able to buy and sell units are those involving a cash sale. And when people are unable to sell their units or refinance their units, you are going to hear about it. They are going to be sending you multiple emails, multiple times a day, wanting to know what you are going to do to fix their problem so that their purchaser can buy this unit or so that they can refinance. So we have to stop sticking our head in the ground with these reserve studies and everything else and start making sure that we are planning, because we are avoiding a much worse experience for the association, the board, its members by planning now. So we need to be taking this very seriously. Fannie and Freddie want to see reserve studies updated about every 3 years. There is some new guidance where it's not as problematic if you don't have that, but the goal is every 3 years you're having a reserve study, and an engineer is coming on site and looking at your property and determining whether the things that are in your building are in good working order and there's not a safety concern for your residents. So this is something, again, I'm imploring boards, please take this seriously and start making plans. If you know your balconies are about ready to fall off the building, start talking about it for your budget and have the plan for next year so that when the weather breaks, you can start making those repairs. If your roof's at the end of its useful life, same thing, facade, get those things taken care of that have to get taken care of. And as Eric said, the more time that we have to plan and to set everything up, the better that it is for everybody. So it's better for the board because you have a very clear plan that you're able to articulate to your members, including this is how we're going to pay for it. And it's better for your members so they're aware, okay, here's what's happening, because nothing is worse than having to go in front of your membership with an emergency special assessment of, guys, I'm really sorry. I need $15,000 and we need it within the next, 30 days. You can't override it because it's an emergency. This has to happen. And, we're going to need this money now. So off to the next fun slide. So that was a doom and gloom side. All right. Don't forget your role. Again, remembering, your job is to make decisions. You are the most local form of government that there is. You're like the municipality, Congress, all those things. You are making decisions. Your job is to make sure that you're maintaining the common elements, that you are making the decisions that the association needs. The number of boards that don't want to make decisions can be very frustrating for me sometimes. I'm sure the same for Eric and Carrie. The board, you're an entity. The association acts by a majority vote of its quorum. Unless the board has delegated authority to a particular board member, no one board member has more authority than the other. When I work with new boards after an election, and officer roles are announced and somebody's all excited, like I'm president, and it's like, you are president of the board of a homeowners association. That means you get more work. Congratulations. But you do not get more power. You're the point person. You're going to get the emails. We're going to look into you to figure out what's going on, but you are one person out of this board, and the board acts by a majority. So as board members, it's important to make sure that you understand what your role is. Your role is to govern your association, to make those decisions. You need to put the team in place that is going to work for your community. Your manager, and I'm going to turn this over to Eric in a second, he's the ringmaster of the 3-ring circus that is your association. So getting your manager in place, getting your accountant, your insurance agent, your attorney, all these people that are here to help work with you and help make your association better. And Eric, I'm turning it over to you.
Yeah, I think really well said, Dawn. The things I'll add to that is we actually, I don't have to call them out individually, but one of the attendees on the meeting actually was a source of inspiration for a lot of other communities that we managed. But I remember that this particular individual, every time that there was a board election for the annual meeting, there was a really great summary kind of report document that he always included as president, and it just as a board member at large, even to just remind board members that were elected of those of like their roles, of the actual definition and responsibilities that fall under a president, under a secretary, under a director at large. And it kind of played as this orientation meeting to kind of get new board members acclimated to it and understand that, because especially for fresh board members who haven't been, served on not only an HOA board, but a board of any kind, sometimes you're coming in not knowing the difference. Sometimes your perception as a homeowner might be that, someone with, Brian mentions in the chat, and we'll get to that question, an answer to that question a little bit later when we get into Q&A, like personal risk of officers versus like members at large, things like that. But understanding what that actually, I think that there's a perception sometimes that just because you're a president, there's more authority that exists. There are, you're a more senior member of the board, and with that comes additional sort of voting rights or whatever the case might be. And obviously that is not the case. We sometimes
don't have a veto as the board president.
Yes, precisely. You don't just get to strong arm, just because you're the person that's been in place for 10 years and you're largely the one that people have deferred to. There might be a person with a different perspective that's just as viable of a solution to consider, and they have every right for that to be heard amongst the board, the same way that you as president or you as secretary or you as treasurer has in terms of sharing their opinion and feedback about these particular situations. We do have some write-ups that we've included and started sharing with folks if they want to have kind of some board orientation documentation to share with their boards, fellow board members, either, during your term or upon a new election, to kind of just ensure that you have a sense of what are my duties, what are my responsibilities, answering questions like, do I have more authority or responsibility versus someone else among the board? And clarifying those things is always helpful. Annual meeting's a perfect time to do that because it's fresh. You probably do have a new board member. There aren't junior board members. There aren't people that, hey, while they're getting their feet wet, let's not include their opinion, or they don't really get a decision, making vote on this. They have that same opportunity to share their opinion and their vote the same way that you do, whether they have been on the board for 3 days or you've been on the board for 3,000 days. So just remember that, just because of your tenure, just because of your authority and respect amongst the community, it does not necessarily put you on a higher echelon or on a pedestal outside of, beyond your fellow board members as well.
All right, Carrie, I'm going to try to get the next three pretty quickly. Don't forget to communicate. Don't fail to communicate expectations. This is something that I see happening in communities all the time. Communicating with your fellow board members what the expectations are of being a board member, and kind of going back to Eric's point about doing a board orientation of, okay, here's what this means to be a board member. You're going to get a board packet, and the board packet is going to be delivered on this day. The expectation is that you're going to read this board packet before you come to the meeting, and you're prepared, to discuss the board packet, as opposed to, you're going to show up to the meeting 5 minutes in advance and start reading the board packet, and all of a sudden there's all sorts of questions and we're not able to conduct business because the expectation, was not met or not communicated. When you are trying to get information from your board members, we need to figure out our next meeting date. It is important to put a deadline in your title of your email. If you want a response by a date certain, we need to schedule a meeting. Please provide your available dates by Friday. What is Friday? The 19th? September 19th. And putting it in there so that you are making it clear to your members what it is that you need from them so that we can move the association forward. Same thing goes with communicating to the members of the association's team. Carrie and I, when we were preparing for this today, I kind of brought up the thing that I love about Carrie is Carrie will reach out to me via email and she will make it abundantly clear when she needs something back from me. Like, I have a contract, I need the contract back by Monday so that we can triage things and make sure the deadlines and expectations are being met. Same thing with owners. Your rules and regulations. If your rules and regulations haven't been updated in 20 years, and I'm saying this because I've seen way too many rules and regulations that haven't been looked at in 20 years, you want to make them simple. You want to make them a do and don't of community association living so that the owners are very clear what their expectations are as owners. We expect that you do this. We expect that you do that. You must bring in your trash, by the evening at the end of pickup, making it clear so that people know what their expectation is, because a lot of times people just assume, well, they should know that this is what they have to do, or they should know that I needed this now. And if that's not effectively communicated to people, people are not meeting expectations, and it causes a lot of frustration all around.
Big time. All I'll add to that is, like, we're not immune from that either. So, like, I want to encourage, in the interest of accountability, like, if you feel like your manager or us as an organization or like someone us being part of the association's management team and your partners, if we're not making expectations clear on something, let us know about that, because I can't count the number of times, like, when we deal with like an escalated issue where, half the time it might have been resolved with just better expectation setting from our end. Maybe there's different expectation setting that the board could be doing a better job of with us too, just to clarify some of the misconceptions. And maybe we are falling down on something. Maybe the board might be falling down on something, not intentionally, but sometimes the clarity of just having expectations kind of clearly communicated is just really helpful. And it kind of provides an opportunity for reset where you think that there's some lack of clarity as well.
All right, next slide. Okay, this one is important. Do not put things in writing without thinking whether it should be in writing. Please keep this slide, put it on your wall, dance like no one is watching, but text and email like it will be read in court one day from your lawyer. When you are commenting about other residents in the association via email, and you're commenting amongst the board, know that those emails can be subpoenaed in the event of a lawsuit. Same thing with text messages. Same thing with WhatsApp messages or Facebook messages. Anything that you are putting in writing, be prepared to have it come back to haunt you. So if you have commentary that doesn't need to be there, please don't put it in writing. So we will very often get served with a lawsuit on one of our clients' behalf, and it will involve a slip and fall. It always involves a slip and fall. We will send that information over to our client, kind of giving them the instructions of, okay, here's what we need to do. And one of them is, do not discuss this via email. If you want to talk about the fact that Dawn Moody is a klutz and she wears shoes that she has no business walking in, and the only reason she hurt herself is because she can't figure out how to walk, that commentary should not be in email or text messages. You can have that commentary, you can have that conversation, have it verbally. So there is no such thing as board member privileges. Your emails can come back to haunt you. So if it shouldn't be in writing, don't put it in writing. And the golden rule is the last thing. Don't forget to treat others the way that you would like to be treated. This doesn't matter who you're talking to, the owners, your fellow board members. As I mentioned earlier, I have a lot of boards that do not get along, where we have a divided split, 3 board members think this way, 2 board members think that way. It is very important to treat others the way that you would like to be treated, because while you might be in the majority today, after the next election, you might be in the minority. If you're not treating those minority board members in a good way, when they have the majority, they're going to treat you in a way that you're not going to enjoy. So please utilize the golden rule, treat others the way that you would like to be treated. I think it will make everybody's life a lot easier.
Yeah. Couldn't agree more with that one.
And that's why that was the number one thing. Let's break out the golden rule. Treat others the way that you would like to be treated. And we wrapped up with 1 minute to spare.
Well, I got some questions for you, so we're not quite done yet. So we do have a question on the annual budget. What should they anticipate budgeting for the attorney to review contracts?
So I think that's the answer is going to be the typical, it depends. I would talk with your attorney about whether a retainer would work for your association. If you're going to have your contracts reviewed, having a retainer, which is essentially you're paying your attorney a set fee every single month, and it includes certain services, including talking to your community association manager, talking to a designated board member. It can include contract reviews. It can include annual report stuff. It can include opinion letters, rule drafting, all those sorts of things. It might be beneficial to have that retainer agreement in place. Otherwise, it's probably going to depend upon the number of contracts that you'd like to have reviewed each year. So I think if you know we're going to have 4 contracts we want reviewed, have your manager pick up the phone and call the attorney to say, hey, we're looking to budget for next year. We're planning to do these 4 contracts. What do you think we should budget? Because we normally know how much it's going to cost, how much time it's going to take for us to do a writer.
I feel like you read my answer that I typed in the chat there, Dawn.
Great minds think alike.
Or you've trained me well over the years. So there was some questions on insurance that I did answer. But then I had 2 questions when we're talking about board confidentiality and what is the recourse a board can take if board members are having discussions outside of board meetings. And I know this is a hot one because how do you enforce that they're being confidential with that information and not stirring the pot with the homeowners?
I think I want to read that question.
So it says, is there some recourse a board can take if board members are having discussions outside of board meetings? And I know this board member, so I know the board member is essentially taking everything discussed in that board meeting about a potential large scale project and going back and relaying it to homeowners who are hyping it up, and now essentially doing a petition to call a special meeting to discuss the potential loan that hasn't even been approved or finalized yet.
So I normally start out these sorts of situations with it is time for a board refresher. I think everybody needs to get back on the same page about their duties and obligations as board members. It's an indirect way of calling this board member out. And again, reminding people you have a duty of confidentiality and bad things can happen to you personally in the event that you breach that duty of confidentiality. If after that, refresher meeting, there continues to be problems, I think the board is going to have to take action. We've had, unfortunately, there are board members that no matter how many times you tell them what the rules are and that they have access to information that is not supposed to be shared, they share it anyways. They have a personal goal that they're trying to accomplish, and taking that information and using it for their own personal reasons is what they're going to do. And at that point in time, the board needs to protect itself. They need to protect the corporation, and they might not need to vote to restrict that board member from access to confidential information. It's an extreme remedy, but the board has to make sure that the duty of confidentiality is being upheld and that the board is fulfilling its fiduciary responsibility.
Okay.
But I will say 9 times out of 10, hey guys, let's have a refresher here. Let's talk about what you can and cannot do works.
In this case, I don't think it will, but the answer was still very helpful for us. Another question is, if deferred maintenance causes homeowners to not be able to sell, buy, or refinance their units, can homeowners pursue legal recourse against the association?
Anybody can sue anybody for anything. But let me tell you, filing a lawsuit is not going to get you off of Fannie Mae's blacklist anytime sooner. And I say that because litigation also is something that they're looking at when they're deciding whether to allow, approve a loan. And if it's the sort of litigation that's not going to be defended by the association's insurance carrier, they're not going to lend, regardless of the dollar amount at issue, until that is resolved. So I don't think filing a lawsuit is something that helps. And in terms of whether you'd have any sort of recourse, I mean, the board would have to do something pretty egregious. Certainly there are boards that have done some pretty egregious things, like take a reserve study, realize that it was absolutely terrible, and decide to pretend that it never exists and not raise assessments for 10 years. That's something that could be actionable. But as both of you know, especially over the last 10 or so years, 20 years to be honest, there's always been a reason that boards don't want to put forth the budget that the business actually needs. We had the recession, we had COVID, we have the tariffs. There's always some reason that we're not doing what we need to do. And the question is whether the board's action in not raising assessments and having this issue rises to the level of a breach of fiduciary duty. It's very fact specific, but unless you have the worst brain wreck of a situation out there where the board completely stuck their heads in the sand like ostriches for the past 10 years, you can file a lawsuit. I don't know that you would.
There's another one regarding the board members that are not performing. What's the recourse of the board? I'm kind of responding just then that it would be a special meeting to vote to remove that board member, in which you would need a percentage of the owners to vote in favor of that. But beyond that, you can't just kick them off because they're not doing anything.
Correct. I mean, I'm a big fan of, again, having those conversations of, hey, we need you involved. This is what we need from you. This is what you're here to do. And if you are not willing to contribute to this board, you really should think about resigning. And if they won't resign, again, the bar to get a board member removed, it's easier to remove somebody from the position of president, an officer position. So the board can say, hey, Eric, we're voting that you're no longer president of the board. But to take Eric off the board completely, that requires a vote of the membership, and it's normally 2/3 of all of the membership in order for that to be successful. It's a very, very high bar. So
then that same board member can rerun and ultimately get reelected if those same people don't vote against that board member.
Yeah.
So,
but that's why you got to go find a replacement. You got to find that better board member.
So a question was on how to get people to attend and participate. Generally it's if you're doing well, nobody participates until something goes wrong, and then everybody shows up at the board meeting. Is there a way for the board to kind of restructure how they run it so more people can do their share? And my suggestion was more to create committees to delegate to homeowners to assist in the board. But ultimately it's at the board's discretion. And then Ida does say that it wasn't as funny as Letterman's list. So we need to work on that, Dawn.
I'm somewhat funny as an attorney. I'm not Letterman good, but I mean, I try to be funny.
Lorraine, I see that if you're still on here, you mentioned issues with Westward. What would the association do if the issue is with Westward itself? Who do they turn to? External lawyers. The association has its own lawyer, so that's not affiliated with Westward in any way, shape, or form. But there is supervisors to your manager. So there's different layers of escalation that board members have, whether there's a director in place that oversees the managers. The general manager could also potentially be available. And then there are our vice president of the managers division. There's Eric himself, who jumps in a number of times when we have issues and is happy to help. So Lorraine, if there's a specific issue, you could reach out to myself or Eric and we can help you through that.
And I think just to add to that, just to remember, and I think because I do get this question sometimes with like the attorney relationship with like the association itself, I think this gets convoluted sometimes. But remember that like whether, maybe Dawn and Keough and Moody are your attorney at your community, maybe KSN or another, whatever the case might be, they're an association vendor. Like they are not, while we deal with them and we will communicate with them as your agent, as your management company, they're ultimately your vendor. Sure, do we have a good relationship with your vendors and the representatives of your vendors with whom you work? Absolutely. If we ever go through the unpleasant sort of experience of having to go through anything that's threatening litigation or something that we really hope never happens like that, you would still be working through your attorney in most cases. That's why they generally have their own, Dawn might be your representative for, more day-to-day matters, but then there might be a litigation attorney that gets involved so that there is like another sort of outside party within the firm who's handling, that litigation aspect. So do remember that the attorney representation for the association is just that. They are representing the interests of the association the same way, when we, might send a renewal contract for our management services. We'll encourage you to have your attorney look at that the same and vet our contract the same way that they would vet your landscaper, your roofer, any other sort of person that you're contracting with the community. They're ultimately representing your interests. So whomever your attorney is that you're contracting with, they will still be your resource. Maybe they'll get different personnel involved, but do remember that they're representing you. They're not representing us. We might communicate with them, but they're representing your interests and the association's interests, not Westward 360's.
Yes, our client is the association governed by its board. That is who our legal obligation is to. We work with your managing agent as part of the association's team. So kind of going back to what Carrie was saying at the beginning, from time to time, I will get those phone calls when things are happening and, expectations need to be realigned and trying to figure out the best way to have that conversation. Sometimes boards are uncomfortable and reaching out to Carrie to say, hey, I think we have a personality conflict. I think the board would be better served with a different manager. And your attorney is, our job is to help our clients solve their problems. Again, we would like to prevent as many as we possibly can, but if you have a problem, we're here to help work through, okay, this is how we solve it. And a lot of times that is picking up the phone and having the conversation with the board and with management to get everybody back on the same page to have a good working relationship together. But our client is always going to be the association.
Well, we hit all the questions, though. The last one was that Jeff had, where is the replay coming? So Eric, can you reiterate that? Oh, you're muted.
We muted her.
Darn, I almost made it through without flubbing that. So yes, we will be sending out a recording, a copy of that. The YouTube link will go out to everyone who was on the RSVP list. So you will get it via email. It will also be uploaded on our website. If you don't mind, bear with me just for a very quick second, because I can show you exactly where you can find those on a moving forward basis. And a lot of them are already up there. But if you do find yourself on our website, if you go to this nifty little education section, you can see as you scroll down some of the upcoming, we have the top 10 board don'ts. We have a couple of events that are coming up. Cooperator Expo coming up October 16th that we'll be attending and presenting at. On the left-hand side, though, you have all the links to all of our previous sessions as well. So this one, we do have one around budgets that we just did recently, along with a couple of more intimate sort of interview sessions that I did with one of my colleagues, Mike Daly, around common budgeting mistakes and budget best practices, things around reserves financing and lending opportunities. Dawn's last session around electronic voting and electronic communication is up here. So this will be up there later this week. If you want to take a look at the recording there, it's all linked through our YouTube page as well. And then that'll be your kind of ever-living repository for any of those sort of sessions and recordings as well.
Perfect. And then the last thing, can we email out the PowerPoint to the people that attended tonight?
Yep, absolutely. We'll include a copy of that presentation with the email that goes out to everyone as well.
Perfect. I think I got through them all, and I apologize. I think I answered some of them, so I wanted to make sure. If not, please reach out to us, and we can definitely help on that. But otherwise, we made through everything, just a little over. So
Thank you very much for having me this evening to talk about top 10 board don'ts. I very much enjoyed it.
Thank you, Dawn. Very much appreciated. We really appreciate your expertise. And stay tuned. We'll have invites going out for our next sessions coming up in October and November. So stay tuned. If you got this invite, you should be getting invites going forward for our next upcoming events.
we did have, I know we were kind of pointing up, Mary Louise just raised her hand. So I just want to, if we could, before we jump off. You're muted though.
Yeah, you're muted, Mary Louise, if you can unmute really quick. Should be a little microphone kind of icon towards the, there you go.
There we go.
There we go.
I want to apologize first for being late. I had a little plumbing emergency, but this was a great talk. And I want to tell you that your representative here in Las Vegas has great hustle, because we have another management company for our HOA at the present, but he keeps in touch and keeps himself on our mind. And he forwarded me the information for this. And I'm a board member, I'm the president. And, you know, like, I don't care who the association management is. I appreciate all the information and all of the advice you guys can give us, because we're kind of new to this stuff as a board. So
that's excellent. I really appreciate that feedback, Mary Louise. And I will say, like, for any of you that aren't current customers, that's entirely okay. You know, whether we've managed you in the past, whether you've been someone that we've talked to since, whatever the case is, like, this is meant to be educational. This isn't meant to be gatekept so that only our clients can see it. We want, you know, this everyone kind of rowing the same direction makes it a better industry, makes it better in terms of board members operating up to snuff. So whether you ever do business with us on a managerial level, or just, you know, want to be able to consume some of the opportunities that we have here and learn a little bit, I'm glad that people are getting value out of it. So that's nice to hear.
well, thank you all very much. I appreciate that. And this was a great little learning lesson.
Corinthia, I know your hand popped up. Did you have something, or was that an error? You're good? Okay. I think we're good. Thank you, everybody. Have a great night.
Thanks,
Thank
everybody.
you. Good night.